Oxford. And it is expected that this number will rise to 3 billion in 2030. So it is key, crucial need and very urgent need of human beings. But this is only one reason. The second one, as I mentioned at the beginning, is this is really fascinating field of law because this right to housing is mentioned in many constitutions now. It is the number of this constitution is increasing still. It is more than 80 constitutions just recognize, the right to housing in their wording. And this number increased very fast by 25, for example, between 2000 and 2025. So this is the area of law which is very quickly developing. But the third reason, and the most important for me, is that it is still underdeveloped in the theoretical sense. So we know that it is a very basic need. We know there are wording of housing in our constitutions and international documents like European Social Charter and International Covenant of Social, Economic and Cultural Rights. However, we do not know what does it mean, in fact, and what are elements and guarantees of such rights. So this is what I'm working on for 3 years now. I've researched most of national constitutions, and I can say that this right is recognized mostly in constitutions of developing countries. Why? Of course, because of the collective memory of this need, of the poverty and homelessness. But the problem and the need is really vibrant and really very, very serious in European countries also. And European countries are very skeptical about the idea of regulating social rights in constitutional framework. Why? Because it is like a duty to state to not only recognize, but also protect and ensure the adequate level of this right when it is written in the Constitution. So now I'm working on the 3 national regimes, orders and practice, like Germany, France, and Netherlands. And only in a Dutch constitution of the Netherlands, there is a right to housing amended in last few years. So nor German, neither France has no such provisions in their constitutions. But it does not mean that these states have not adequate level of guaranteeing these rights. Contrarily, and France and Germany, as well as Poland, in a sense, has a very big social policies about right to housing, ensuring housing for people, like regulating rent, loans for people, and building social housing, and so on and so on. So, but there are some conundrums, like, for example, horizontal aspect of this right. Because as far as we know, of course, state has a duty to give us some amount of social housing for the very poor people, yes. But most of people live in their own houses or the houses which are rented, yes? And there are commonly private rental contracts. So in such contracts, there is a very interesting, from the point of view of constitutionalists, conundrum of a right to property and a right to housing. Yes. On the one side, we have a right to property, which is absolute, and which means that nobody can intervene in my subject of my property. Yes. And on the other side, there is a habitant who live in my flat, for example, yes, so flat owned by the landlord, and this habitant has also some rights, for example, inviolability of home, yes, and the exclusion of this right is very limited under European Convention and under constitutional framework in our countries. So this is really fascinating, how to work on it and what perspective should be accepted. Is it a perspective of just social rights, like very progressive approach, or economic approach? And now I'm elaborating on the theory of cause, which is a Nobel Prize winner for economy. And the theory of cause, Ronald Coase stated that the assets, like flats, for example, are distributed among people in the best way when the transactional costs are approaching zero, are minimal, and these assets are very well defined. And here is a problem. Can we define really properly and clearly what does it mean, property and a flat and a house in our regimes, and how high transactional costs we can accept? Because when we are talking about the proceduralization, for example, of rights under European Convention of Human Rights, yes, so the states, which means that the states shall guarantee very high level of procedures and judicial control of every decision made by state authorities and made by people, private people under state law. It means that transactional costs, the costs of exchange, transfer of every assets, every goods, every harm, which should be every harm, are very, very high. So this is not the conditions when theory of cause can work. So this is the very, I can say, very not adequate environment to work when we are talking about private contracts and distribution of flats like assets under this theory. So as you can see, this is very, very complex issue. And I just touch a few of elements which are just came to my mind now. But the issue of social rights, especially housing rights, which is really very crucial and very fragile for every person, is worth of mentioning and worth of elaborating. And I'm really very curious, how is it in Turkey? So, because, last week I talked to my friend, which is from Turkey. He's a constitutionalist from Izmir. And I asked him about flats and the problem of homelessness in Turkey. And he said, he answered, okay, we have some homeless people, but surely there is a less number than in Germany or in France now. So as you can see, there is no very simple solution or simply division between, rich north and poor south, like in social rights we used to say, you used to see it. I'm very glad you said that, because what you were saying about and practice of right to housing, it is very similar to Polish problems and the problems of European countries, Central European countries, but not only. From Turkey, I went to Ireland, and it is rare opportunity to see so many homeless people like in Ireland nowadays. So you can imagine how urgent this need is in rather cold European countries, yes, and rather people are rather used to have some, decent level of life, yes, like house, like school, hospital, public service, and so on. And this is ending, I'm afraid. There is, of course, migrant pressure of migrants, of course, but also the problem of cost of living here, because exactly as you said, there is the same problem in Poland. We have a lot of flats, a lot of houses, a lot of apartments, but most of people are in so-called rental gap. This is the place where people who have income decent to live, so they don't deserve the social housing, like for poor people, but they cannot afford to rent a house on the private market, and that's why they are living still with their parents and grandparents and so on, or in very, very bad conditions. So this is about, there are estimation that in Poland there is about 30% of people. So this is really a lot, because we are talking about young people foremost, yes, not about old people like me who has, the big house, and I don't know what to do indeed, yes, with my husband, only because our daughter is abroad. So this is a problem not of legal provisions in our constitutions, and I can tell you all of you the story about South African constitution. This is the most famous example of right to housing written in the constitution, because in this post-apartheid constitution, this constitution guarantees justiciable socio-economic rights, like right to housing. And this is a very famous ruling about Irene Grootboom. She was a woman living without any shelter, just on the street. She claimed that like a person was forcible, and she was forcibly evicted from his, temporary shelter on the street, from the informal settlement, which was occupied by her. And the court, in her case, decided that the article of the Constitution, it was Article 26, includes not only negative obligation on the state, that the state cannot evict person from their houses, but also the positive duty, positive obligation, particularly the obligation to take reasonable legislative and other measures to achieve the realization of the right to housing, yes, under available resources. And the court evaluated that the state didn't meet these requirements. So Irene Grootboom won her case. And so what? He died on the street like she lived all her life, because this was a very beautiful ruling and a beautiful provision in the Constitution, but they are only words, yes, not a house. So there is a very big problem. And Europe, we are thinking rather about practical solutions for such problems, but I'm still not sure that we, like German authorities, French authorities, and so on, find the adequate and satisfactory solutions, because the problem is growing, not vanishing, not diminishing, but still growing, and there are